The reason I'm speaking tonight is about an issue which I think many people in Western Canada underestimate. As Glenn has just suggested, if we take the southern part of Alberta and portions of all 4 provinces of Western Canada, we have a bit of a problem. We've basically allocated all the available water, and what I'm interested in is twofold. How do we accommodate new users in basins which are fully allocated? And secondly, how do we do so at the same time as improving environmental issues relating to the flow of water in existing rivers? So first of all, I want to tell you how we got here. And I think it's a brief but interesting historical discussion because the first piece of resource legislation passed in relation to the prairie provinces was the Dominion Lands Act, which led to homesteading, 1887. By 1894, the federal government realized that agriculture in large parts of the prairies could not be carried on unless they had a reform of water law which allowed allocation of large amounts of water to farmers in a way that wasn't allowed by what was the prevailing law of riparian rights at the time. So the first thing the government does when it wants to control a natural resource is to declare that it owns the resource. And that is exactly what they did in 1894. The words are still found in Alberta today. They say the property in and the right to use all water is vested in the Crown. Those days the federal Crown, now the provincial government. And having got that far, they said, right, we own all the water, and no one can use this water unless they first get our permission. And so what they said was, if you want to use and divert water anywhere in Western Canada under this legislation, it spread from Manitoba to Alberta, you can only do so if you obtain a license from the government. So not in 1894, because it was Murphy's Law, there'd been a 7-year drought leading up to this legislation, and then it rained for about 6 years. So nobody really bothered getting water licenses until after 1900, but the government began granting water licenses to use water, to divert and use water. And they granted those licenses without any expiry date. They were licenses without a legal term to them. Now, they are treated by those who hold them as if they're perpetual in nature because they don't have an expiry date. But trust me, there is a difference in law between a right issued without an expiry date and one that's perpetual. Despite the belief of many holders, these licenses are not perpetual, but they do not have an expiry date. And the other thing which was interesting was that they granted rights to consume and divert large quantities of water. Now, the other thing that the government thought of at an early stage is, well, we've given out these licenses. What if there's not enough water around to meet the needs of every licensee? So they then declared a principle which was borrowed from the states south of the border called prior allocation. Now, this is really startling when people first hear about it because it says that if there's not enough water to go around in a given basin, the right to get that water depends on seniority. The person who holds the oldest license is entitled to get all the water stipulated in the license before the next junior licensee gets any. So basically, in a drought, the theory is if there's not enough water for all licensees, the junior licensee is cut off first, then the next junior licensee, and so on, until in theory, it might only be the senior licensee who has, in those days, the gates open so their farm could be irrigated. So this doctrine is startling. It's more startling in theory than it is in fact, because actually in the 120 years of history of Western Canadian water law, I haven't found a single instance where water supply was cut off to any major water user, even during a very serious drought. In practice, because water users form a community, droughts tend to be shared rather than having people insist on the strict priority which the law entitles them to. Well, that's the basic scheme of the water law that governs Canada from the Lake of the Woods to the Pacific coast. It's all identical in principle, but it has an inbuilt problem. And the inbuilt problem is how do you accommodate new users once you've fully allocated the water in the basin? And believe it or not, this dawned on the government as early as 1921. It occurred to them that the system they'd invented had a bit of a flaw in it. What happens when you've allocated all the water and somebody else comes and knocks on the water allocator's door and said, we'd like a water license, and the response is, I'm sorry, we're fresh out of water today, you can't have it. Well, the concern then in 1921 was there wouldn't be enough water for the growing municipalities, towns like Lethbridge and Medicine Hat, which actually had very rapid growth after the First World War. And what I'm interested in is what are the options that are available to government in dealing with this overall problem? Well, first of all, let's look at the list. If you have any public discussion of this issue, the first two options on this table are the most popular ones. The first thing every public survey will tell you is, look, if we need to accommodate new water users, we should reallocate water to those uses which are now most important to society. In other words, we should reallocate water according to the relative importance of the use. The second answer, which was given by a lot of people in Alberta in every survey of opinion on this, is that we should allow the government to reallocate water from existing users to new users in the public interest. So they're the answers in every survey which members of the public come up with. If you don't do that, the third choice is to fudge the issue, because water will move from existing users to new users whether you like it or not. Fudging the issue is what happens in British Columbia. I'll come up with that in a moment. The fourth possibility is to allow the voluntary transfer of a water allocation from one user to another, and I add this last phrase very importantly, subject to a strict level of scrutiny by the regulator. Now, what's really interesting about Western Canada is we have 4 provinces, and each one has tried one of these variants. So the 4 systems we talk about there's an example of each of them. Let's just quickly have a look at them. First of all, in Manitoba, their act says where water is fully allocated, if an applicant proposes to use water for a purpose that is higher in priority, a more important social use than that of other licensees, the minister can issue that person a license and can cancel or restrict the rights of any more, one or more of those other licensees whose water use is less important than that of the applicant. And it does allow some compensation for loss or damage suffered by the person whose license is cancelled. This has existed in 1921. It used to apply in Alberta, Saskatchewan, and Manitoba. It now only remains in Manitoba. So the big question is, if you believe that water should be transferred to the most important social use, how do you do it? It sounds great. Well, the answer that Manitoba has is we have a list of purposes. It's a league table. The basic rule is if you're higher in the league table, you can acquire the water license of someone who's lower down in the league table against their wishes, but on payment of compensation. This table again applied all across Western Canada. The only thing that happened in Alberta in 1975, it used to be the same table, is irrigation got promoted in the league. After several years of good drafting, they went from number 5 to number 4 in the table of importance of water uses. So that's the first one. That's the only system we have in Canada, which now, but we all used to have it, which says we'll reallocate water according to the importance, the relative importance of water use. Predictably, that table might have been good for 1921, briefly, but social priorities change. The same table applied in Brandon as applied in Flin Flon. The same table applied in Port-de-la Prairie as applied in Fort McMurray. That was the whole idea, that we have one list of important purposes, but of course, whether those purposes are the most important today or the most important in every region is always open to debate. Then we had Saskatchewan, the first people to reform this in 1984. They said, we're changing our act to say that the government can reallocate water in the public interest when there's not enough for all the applicants in a given basin. And they say that any right to water granted under license can be cancelled by government when it's in the public interest to do so. Well, this is incredibly controversial amongst water users in Saskatchewan, as you might imagine. If you're getting the water, you'd say, oh, the government administrator is a wise administrator. If he's taking the water away from you, you say that's a goddamn bureaucrat. And that's exactly what happened. So in 2005, the Saskatchewan government said, we'd better put some control on this. So now you can only get a water transfer, a transfer of a water allocation in Saskatchewan if you get the approval of the cabinet. Well, you can imagine how long it takes to get a cabinet approval, even to get on the cabinet's agenda. And then the Saskatchewan said, and we'll give you compensation just like Manitoba does, but our compensation is on the value of the works, any works that are rendered redundant as a result of this loss of water. In other words, works that are stranded because you no longer have any water right or as large a water right as you had before. They're the first two taken care of. Let's now move to fudging. Because fudging, is what happens in BC. Now, if you read the BC Water Act, which you do if you're a severe insomniac, it appears that no transfer of water allocation is ever possible. But there's a sneaky little section in there in BC which says the controller, the guy in charge of water, or a regional water manager can do two things. Water rights, water licenses are attached to land. They're attached to the land in respect of which the license is issued. The Act says they can transfer the appurtenance of a water license. They can move it from this land over here to that land over there. It's okay, that sounds convenient. And they can change the use of the water that's established in the existing license. A typical use of water will say you have this license for irrigation purposes. Well, you can change that use under the BC legislation for fracking purposes, or for orchard purchases, or for wineries. And the amazing thing about this is that these decisions are made at the level of regional water manager. The regional water manager can waive public notice of what's going on if, in the view of the manager, there are no private rights that are harmed. So what we have in BC is water transfers going on, and nobody knows about them. Because the regional manager said, I don't think it's going to affect anybody else's rights, and all we're doing is changing the land to which the license is entitled, and we're changing the use of water set out in the license, and bingo, water's been transferred from the Okanagan, from a peach orchard to a developer of acreages. And it happens, and there are no real safeguards. In fact, a number of transfers have happened under this in BC, which I think are distinctly contrary to the public interest, and which would not be allowed under the Alberta system. Which brings us to the Alberta system. Alberta, when they faced these discussions in 1996, we decided very controversially to simply allow the transfer of water allocations. You hold a water license, and in principle, you can transfer all or part of your allocation either permanently or on a temporary basis, not everywhere, but only in an area of the province which is covered by what is known as an approved water management plan, or there's a cabinet order that covers that relevant area of the province. And I'm sorry, this next slide was a bit repetitive. So the important thing is it's where an approved water plan or cabinet order covers the relevant area of the province. And at the moment, in southern Alberta, we are fully allocated in at least 3 basins, the Bow, the Oldman, and the South Saskatchewan River Basin. And the South Saskatchewan River Basin plan allows the transfer of water allocations in that basin only. There's no other approved water management plan. So since 2001, in the southern part of the province, we've allowed the transfer of water allocations. I mentioned earlier that any good system in this regard has to have safeguards, which we have, but BC does not have. And the idea is that every application for transfer should be subject to the same level of scrutiny as if you were applying for a new water license. You obviously cannot transfer more than you have. There must be no net harm to other water users or the environment. If it's a transfer for irrigation purposes, the land must be suitable, and there is a consideration of the amount that the licensee has historically diverted. You may have a license for 100,000 acre feet, but if you've only ever diverted 80,000 acre feet, it's really important you not be allowed to transfer more than 80,000 acre feet. Otherwise, the river will suffer even further. And the safeguards are enormous, because in addition to those safeguards, the director must conduct a public review. They cannot waive notice, like BC. They can't waive public notice. And they must review all 4 factors contained in the Water Act, 14 more factors contained in the South Saskatchewan River Basin Plan, and 7 discretionary factors that are set out in the Act. So basically, no transfer of water allocation can occur until a total of 25 factors have been examined by the director to ensure that the transfer of water application is in the public interest and not harmful to the environment. As far as the environment is concerned, we have only one safeguard. I think it's small, but at least a step in the right direction. These rivers are heavily allocated for sure, and the Act does say that when any transfer happens, there is now that it's mandated by the plan, a holdback of the 10% of the water transferred will be maintained in the river. So if you transfer 1.5 million acre feet, 150,000 acre feet are left in the river, and the rest is transferred to the person acquiring it. So that's what we have. I don't think we're done on that. I still think, as Jason will be describing later, we have problems with minimum environmental flows in these rivers, and we do need a more credible plan to achieve those minimum flows. I think it's notable. Last December, I conducted a survey of Alberta water transfers. 123 had occurred in the last decade in what was basically a wet decade, so there hasn't been a lot of stress on water in the last 10 years, versus none in Manitoba, none in Saskatchewan, and goodness knows how many in BC, because you can't tell. But the fact is there were 123 transfers that happened. I would say that's made 256 people happier. The transferor was happy to sell the right. The buyer was very happy to buy the right. They're virtually all within the agricultural sector, from one agricultural user to another. And I would stick my neck out and say not a single one was controversial from the point of view of water management. So I do think of the four systems. I'm not saying that the role of the market system is the best one, but I think it's a lot better than its alternatives, because the other ones all involve forcible removal of water from one user to another, or if you're in BC, you're pretending that that motion of water right's not happening, and you're actually making it so cumbersome for a water transfer to happen that desirable transfers do not occur that is a transfer to a more highly valued use. So that's my thumbnail sketch. As I mentioned in this last slide, I do think we need a credible plan to protect in-stream flows. And finally, we are getting that to some extent, because now that people understand the licensing system much better, there are some very good cooperative schemes for managing the river in a way which suits all licensees and significantly improves the minimum flows in the river. And the best example of this is a project going on called the Bow River Project, where very complex modeling has allowed licensees to determine when they will take water and to increase the amount of water that's left flowing in the stream. But that's probably a story for another day. So thank you indeed for your patience.